Did you know that unconscious bias, well, it can sway hiring decisions a surprising amount of the time, often without anyone even noticing?
It really speaks to just how complex and critical fair hiring practices are today.
Absolutely. Welcome, everyone, to The Deep Dive. We're the show that cuts through all the noise to give you those essential nuggets of knowledge you need.
And today we're taking a truly strategic look. We're diving into a core area for any HR pro, especially if you're aiming for or maybe already hold that SPHR certification.
That's right. This is the SPHR Deep Dive. And our mission today, it's really to equip you with the strategic thinking needed for this complex, constantly changing world of employment discrimination and fair hiring.
Yeah, we're not just listing laws. We want you to think like an SPHR.
Exactly. So we'll unpack key definitions, look at major laws, including some really important recent updates like the Pregnant Workers Fairness Act.
And those big shifts around affirmative action, big changes there.
Definitely. Plus, best practices for recruitment, that strategic mindset that sets leaders apart, and crucially, those common pitfalls. We want you to steer clear of those.
Okay, let's dive in.
So, where do we even begin with this?
Well, I think we have to start with the absolute bedrock, equal employment opportunity, EEO.
Right, EEO.
For an SPHR, EEO isn't just about checking a legal box. It's really a strategic engine.
How so?
Well, the core idea is when you truly commit to equal opportunity, you're not just avoiding lawsuits, which is important, obviously,
Of course.
but you're also tapping into talent pools your competitors might be completely overlooking. It's really about making sure everyone gets an equal chance.
a fair shot.
Exactly. Fairness, merit-based decisions. That's the goal.
And that brings us to protected classes, right?
Yeah.
Understanding what those actually mean.
Yes, fundamental. These are the groups of people protected by law from discrimination.
So, federally in the U.S., we're talking about race, color, religion, sex.
And sex is a big one now because it includes pregnancy, sexual orientation, and gender identity. That's evolved quite a bit.
Virtually. Okay.
Okay, then you have national origin, age specifically 40 and over, disability, genetic information.
Genetic info like family medical history.
Yes, exactly. Also military or veteran status and citizenship status.
And it's worth remembering, state laws, even local ones, can add more protections, can't they?
Oh, absolutely. And global laws if you're multinational.
Yeah.
It gets complex.
Okay, so a really crucial distinction SPHRs need to grasp is between disparate treatment and disparate impact. Can you break that down?
Yeah, this is key. Disparate treatment is the intentional kind. It's deliberate, unequal treatment based on someone being in a protected class.
Like a manager saying point blank, I'm not hiring women for this job.
Exactly that. The intent is clear. It's conscious bias in action.
Okay, but then disparate impact.
Mm.
That sounds more subtle.
It is, and often much harder to spot because it's usually unintentional. This happens when a policy or practice seems neutral on the surface.
Like it applies to everyone equally.
Right. But its effect is to disproportionately screen out or disadvantage a protected group.
Can you give an example?
Sure. Think about maybe a strength test for a job that doesn't actually require heavy lifting. It might unintentionally screen out more women than men, even if that wasn't the goal. The policy looks neutral, but the outcome isn't.
Got it. And isn't there a rule of thumb for spotting potential disparate impact?
Yes, the 4/5 rule, or the 80% rule. This is like your early warning system.
Okay, how does that work?
Well, you compare the selection rate for a particular group, say women or a specific minority group, to the selection rate of the group that gets hired most often.
Right.
If the selection rate for the group you're looking at is less than 80% or 4/5 of the rate of the most successful group, that's a red flag.
Or a red flag, but not automatically illegal.
Exactly. It doesn't automatically mean illegal discrimination occurred, but it signals potential adverse impact, and it absolutely means you need to investigate further.
So, using the example from the study guide, if Group A has a 50% selection rate and Group B only has a 30% rate.
Right, you calculate. 30% divided by 50% is 0.6, or 60%. Since 60% is less than 80%, the 4/5 rule is triggered. You've got a potential issue there.
And if you find that kind of impact, what's the next step for the employer?
The burden shifts to the employer to validate that selection tool or practice. Meaning they have to prove it's genuinely job-related and necessary for the business, consistent with business necessity.
And they also have to check if there's a less discriminatory way to achieve the same goal.
Right, absolutely. If a less discriminatory alternative exists that serves the purpose just as well, the employer should really be using that instead.
Okay. Now, there's also this thing called a BFOQ. Bona fide occupational qualification. Sounds like a narrow loophole.
It is very narrow. A BFOQ is a limited exception that allows discrimination based on a protected trait, but only if it's absolutely essential to the core operation of the business.
Like needing a specific gender for authenticity in acting, or maybe for privacy in a locker room attendant role.
Exactly those kinds of situations. Authenticity or privacy. But, and this is critical, a BFOQ never applies to race, ever.
Good to know. Never for race. And we should also quickly mention harassment and retaliation here, shouldn't we?
Definitely. They are forms of discrimination. A harassment creates a hostile work environment, could be sexual, racial, based on religion, whatever.
And retaliation.
Retaliation is punishing someone for asserting their rights, like firing someone for filing an EEO complaint, or even for participating as a witness in an investigation.
And retaliation claims are pretty common, right? Sometimes even more common than the initial discrimination claim.
They are surprisingly common and a huge risk area. You have to ensure people feel safe reporting issues without fear of comeback. A retaliation claim can stand on its own, even if the original discrimination wasn't proven.
Okay, so that covers the core concepts. Now let's get into the laws themselves. There are quite a few. From an SPHR perspective, what's the absolute cornerstone legislation?
Without a doubt, Title VII of the Civil Rights Act of 1964. It's the big one.
The foundation.
Absolutely. It prohibits discrimination based on race, color, religion, sex, or national origin. That applies to most aspects of employment for employers with 15 or more employees.
I've heard the mnemonic RCRSN for those five. Race, color, religion, sex, national origin.
That's a good one. And you can add a P for pregnancy, thanks to the Pregnancy Discrimination Act of 1978, which amended Title VII.
Right. And you mentioned earlier the interpretation of sex has evolved significantly.
Hugely. Beyond pregnancy, the big shift came with the Supreme Court's Bostock decision in 2020.
That's the one that confirms sex discrimination includes sexual orientation and gender identity.
Precisely. Based on Title VII, the EEOC guidance reflects this too, so that understanding is absolutely critical for HR leaders today.
And the EEOC, the Equal Employment Opportunity Commission, they're the agency that enforces Title VII and many of these other laws.
That's right. They handle charges, they mediate disputes, they can investigate, and they can even sue employers or give individuals the right to sue. They have significant power.
Okay, Title VII is key. What other major federal laws are crucial in this area?
Well, there's the Age Discrimination in Employment Act, the ADE, from 1967.
That protects older workers.
Yes, specifically individuals aged 40 and over. This applies to employers with 20 or more employees. Key things here. No age preferences in job ads, generally no mandatory retirement.
Got it. Then the ADA.
Right, the Americans with Disabilities Act of 1990. And importantly, the AD Amendments Act, the ADAA from 2008.
Which applies to employers with
15 or more employees.
Yeah.
It prohibits discrimination against qualified individuals with disabilities. And the really core concept here is reasonable accommodation.
Meaning employers have to make adjustments so a person with a disability can do the job. Unless
it causes undue hardship for the employer, which is a fairly high bar. And the ADAA in 2008 really broadened the definition of what constitutes a disability.
Okay. Now, you mentioned a newer law related to pregnancy.
Yes, this is really important and relatively recent. The Pregnant Workers Fairness Act, or PWFA, effective in June 2023.
How does that differ from the Pregnancy Discrimination Act?
The PDA basically said you can't discriminate because of pregnancy. The PWFA goes further. It requires employers, again 15-plus employees, to provide reasonable accommodations for limitations related to pregnancy, childbirth, or related medical conditions.
Even if those limitations don't meet the ADA's definition of a disability.
Exactly. So think things like more frequent breaks, modified duties, maybe flexible scheduling, time off for appointments. It's about proactive support.
That feels like a significant strategic shift towards supporting and retaining pregnant employees.
It absolutely is. Then there's GINA, the Genetic Information Non-Discrimination Act of 2008.
Right. No using genetic info.
Correct. Employers with 15-plus employees cannot use genetic information like family medical history, results of genetic tests, in any employment decisions. It's off limits.
And military service members.
They're protected by USERRA, the Uniformed Services Employment and Reemployment Rights Act of 1994. This applies to all employers.
All sizes.
Small sizes. It prohibits discrimination based on military service and guarantees reemployment rights after service. It includes the escalator principle. They should return to the job, pay, and status they would have reached if they hadn't been away on duty.
Okay. One more big one, IRCA. Immigration Reform and Control Act.
Right, IRCA from 1986. It has two main parts. First, it forbids knowingly hiring undocumented workers. That's where the I-9 verification requirement comes from.
And the second part.
The second part prohibits discrimination based on citizenship status or national origin for employers with 4 or more employees. A key issue here is avoiding document abuse.
Meaning you can't demand specific documents for the I-9 or more documents than required.
Exactly. You have to accept any valid document from the approved lists. And for SPHRs, dealing with hiring non-citizens often involves navigating work visas like H-1Bs or L-1s, which adds another layer of strategic planning around timing and compliance.
Okay, now let's talk about a really major, very recent change concerning affirmative action and Executive Order 11246.
Yes, this is significant development. Historically, Executive Order 11246 required federal contractors of a certain size, typically 50-plus employees and contracts over $50,000, to have written affirmative action plans, or AAPs.
These plans included goals for hiring and promoting underrepresented groups, right, like women and minorities.
Correct. They involved analyzing the workforce, comparing it to availability data, and setting placement goals where underutilization was found. However, and this is the big change, as of 2025, Executive Order 11246 was revoked.
Revoked. So what does that mean practically?
It means the federal government is halting enforcement of race and gender-based affirmative action requirements specifically tied to that executive order for federal contractors.
Wow, but does that mean all non-discrimination laws are gone?
Absolutely not. That's a critical distinction. Title VII and all the other non-discrimination laws we've discussed still fully apply. Contractors still cannot discriminate.
And what about affirmative action for veterans or individuals with disabilities?
Also still required. Those requirements come from different laws, VEV, RAA, and Section 503 of the Rehabilitation Act, and they remain firmly in place. So it's specifically the race and gender-based AAP requirements under EO 11246 for federal contractors that have been impacted by the revocation.
That's a really important nuance for HR leaders and contracting organizations to understand.
Crucial. And if you're working globally, remember, U.S. laws don't automatically apply elsewhere. You'll deal with EU directives, different protected categories, varying cultural norms.
So the global anti-discrimination policy needs local tailoring.
Exactly. Global framework, local compliance. That's the SPHR challenge.
Okay, so we have this complex legal landscape. How does a strategic HR professional actually embed fairness into the day-to-day hiring process? I think the PJ-SIFT framework is helpful here.
It is. Let's walk through it. P is for plan. This starts way before you post a job. It's about workforce planning and defining the actual position criteria.
Based on a solid job analysis.
Absolutely. Define what's truly needed for the job. And strategically, you have to question every requirement. Do they really need that specific degree? Is that much experience truly essential? Unnecessary qualifications can screen out good candidates from protected groups.
Right. Avoid those potential adverse impact triggers from the start. Okay, next is J-job ad and sourcing.
Yeah, how you write the ad and where you look for candidates matters hugely. Check your language, avoid loaded terms like young and energetic or anything subtly gendered.
And include the EEO statement. And maybe mention accommodation availability.
Definitely. Be welcoming. And for sourcing, don't just rely on referrals, which often replicate your existing workforce demographics. Cast a wider net.
Like using diverse job boards, professional associations, maybe partnering with minority-serving institutions.
Exactly. Proactive, diverse sourcing.
Okay, then S is for screen. Shortlisting candidates.
Objectivity is key here. Look at your application forms. Are you asking for things you shouldn't, like date of birth or marital status early on?
Things that aren't job-related and could lead to bias.
Right. Train your screeners, use consistent criteria, maybe structured checklists, and if you use pre-hire tests,
check for validity and adverse impact using the 4/5 rule.
Always. If a test causes adverse impact, you must prove it's valid and job-related or find a better alternative, and administer tests consistently to everyone.
Makes sense. Next, I for interview. This feels like a major bias hotspot.
It really can be the solution. Structured interviews.
Meaning prepare job-related questions in advance. Ask all candidates the same core questions.
And score their answers against predefined criteria. It reduces subjectivity significantly.
And training for interviewers is crucial.
Absolutely essential. Train them on what not to ask illegal questions about age, family plans, health, religion. Even casual chit-chat can be risky, like, that's an interesting accent. Where are you really from?
Oof, yeah. What if a candidate volunteers protected information? Like, I'll need Fridays off for religious observance.
The interviewer should acknowledge it briefly, but then steer the conversation back to the job requirements. Don't probe into the protected characteristic itself. Note it down to consider for accommodation later, if relevant, but focus the interview on qualifications.
And using diverse interview panels helps too, right?
Absolutely. Multiple perspectives help mitigate individual biases.
Okay, F is for finalized selection, making the offer.
Again, rigor and documentation. Use structured evaluation forms based on the predefined criteria. Document why you selected someone and why others weren't selected. Avoid vague reasons like not a good fit.
That good fit can hide so much bias.
It really can. Unconscious bias training for hiring managers is useful here, targeting things like similarity bias, hiring people like themselves, or giving too much weight to prestigious schools.
And maybe doing a final adverse impact check before making offers, especially if hiring a group.
A second look analysis is a great practice, yes. Catch potential issues before they become problem.
And finally, T for take on board. The process isn't over once the offer is accepted.
Right. Background checks need careful handling. Especially criminal records consider the nature of the offense, how long ago it happened, and its relevance to the specific job. Be aware of ban-the-box laws, too.
Those limit when you can ask about criminal history.
Correct. And always comply with the Fair Credit Reporting Act, FCRA, if using third-party background checks. Then there's I-9 compliance, verify work authorization consistently for everyone, avoid that document abuse.
And onboarding itself is an opportunity.
A huge one. Reinforce the company's commitment to EEO, explain anti-harassment policies, show people how to report concerns, set the right inclusive tone from day one.
Following these steps, PJ Sifty, it's not just ticking boxes. It builds a better process.
It builds trust, fairness, and ultimately a stronger workforce. And this proactive approach is really where the SPHR strategic edge comes in.
Right. Moving beyond just compliance.
Exactly. Compliance is the floor, not the ceiling. Strategy is about integrating EEO into everything: workforce planning, talent development, the whole organizational culture.
So using data to see where the gaps are. Setting diversity goals, flexible goals, not quotas.
Yes, proactive planning. And positioning diversity and inclusion not just as an HR thing, but as a core business strategy.
How's that work?
By showing leadership how diversity drives results, innovation, better problem solving, accessing new markets. Strategic HR brings the data, makes the business case, ties D&I metrics to business outcomes.
It's also about fostering that inclusive culture, isn't it? Beyond just the required anti-harassment training.
Way beyond. Thinking about unconscious bias training, cultural competence, maybe bystander intervention training, getting leadership buy-in, supporting employee resource groups, ERGs. It's about making everyone feel they belong and can contribute fully.
And proactive risk management is part of this strategy.
Definitely. Regular compliance audits, reviewing pay equity, using climate surveys to understand employee perceptions of fairness and bias, having robust, trusted internal complaint procedures is key.
Plus, keeping an eye on the future, monitoring legal changes like PWFA, anticipating impacts.
Absolutely. And remembering EEO isn't just hiring. It applies throughout the employee lifecycle: promotions, training opportunities, retention efforts, even terminations. Exit interview data can sometimes reveal subtle biases impacting retention.
And partnering with marketing to make sure the employer brand truly reflects that commitment to inclusion.
Yes. Showcasing a diverse workforce, highlighting family-friendly policies, it makes you an employer of choice.
Okay, let's make this concrete. The TechServe Inc. scenario in the material is a great illustration of SPHR strategy in action.
It really is. You have Julia, the SPHR HR director. She notices a problem. Women are 30% of applicants for software developer roles, but only 10% of hires.
Big gap, potential adverse impact, right?
Exactly. So Julia doesn't just note it, she digs into the data. What does she find?
Well, first, their internal coding test has a much lower pass rate for women, only about 51.5% of the male pass rate. Way below the 80% rule.
Ding, 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 red flag number one.
And second, women seem to get slightly lower subjective scores in interviews.
Red flag number two. So Julia investigates why.
And the coding test. Turns out it was homegrown, never validated, and included weirdly specific questions about a gaming algorithm more familiar to guys, totally irrelevant to the actual job.
A classic example of an invalid test creating adverse impact. And the interviews.
All male panels, apparently, and asking female candidates biased questions like, can you handle our intense culture? We do all-nighters sometimes. Questions they weren't asking male candidates.
Ouch. Clear, disparate treatment creeping into the interview process. So what does Julia, the strategic SPHR, do?
She takes action. She replaces the bias coding test with a properly validated job-relevant one and monitors it closely.
Good, fixing the tool.
She implements structured interviews, trains everyone on avoiding bias and illegal questions, ensures consistent questioning,
Improving the process.
and adds female engineers to the interview panels.
Mitigating bias through diversity, smart.
And she doesn't stop there. She starts affirmative outreach, partners with Women Who Code,
Expanding the pipeline.
and sets a flexible placement goal, explicitly not a quota, of aiming for 25% women developers within 2 years.
Setting aspirational targets based on availability, which is perfectly legal and good practice.
She also updates all the policies, EEO, anti-harassment, to be crystal clear about gender bias and the new PWFA accommodation requirements.
Ensuring policies reflect current law and best practice.
And finally, accountability. Quarterly reports on diversity metrics go straight to the execs, and diversity hiring results become part of managers' performance goals.
Tying it to business results and manager accountability, that's truly strategic.
And the outcome? Hiring rates for women improved dramatically, well past the 80% threshold. Legal risk plummeted. They accessed a wider talent pool, and their reputation improved.
It's a perfect case study. Julia didn't just react. She diagnosed the systemic issues and implemented proactive, data-driven solutions. That's SPHR-level thinking.
Absolutely. A great example of turning compliance into a real strategic win. Okay, as we wrap up, let's quickly hit some key takeaways and common pitfalls again. These are crucial.
Definitely. First, always remember, disparate treatment, intent. Disparate impact, effect. They're different.
Second, that 80% rule. It's a guideline, a red flag for investigation. It's not an automatic law violation. Context matters.
Third, BFOQ. Very, very narrow exception. Never, ever for race. Only for authenticity or privacy in rare cases.
Fourth, affirmative action does not equal quotas. Quotas are usually illegal. AA is about good faith efforts, outreach, maybe flexible goals, but hiring decisions must always be based on merit.
Fifth, know the basics of the key laws and who they cover. Title VII, ADA, GINA, PWFA generally cover employers with 15-plus part. ADEA is 20-plus dot. IRCA is 4-plus. USERRA covers everyone.
Sixth, don't forget, sexual orientation and gender identity are now considered part of sex discrimination under Title VII, thanks to Bostock. That's settled for now.
Seventh, the pregnancy distinction. PDA prohibits discrimination. PWFA requires reasonable accommodation. Two different but related obligations.
Eighth, watch out for retaliation. It's a separate violation and often easier to prove than the original discrimination claim. Protect your reporting process.
Ninth, if you work globally, remember, U.S. laws aren't universal. Think global policy, but always ensure local compliance.
And 10th, if your tests or selection tools cause adverse impact, you must be able to prove they are valid, job-related, and necessary, and show you considered less discriminatory alternatives. Defensibility is key.
You know, mastering this area, employment discrimination, fair hiring, it's just fundamental for HR, especially at the SPHR level.
It really goes beyond just avoiding legal trouble, doesn't it?
Oh, absolutely. It's about building a genuinely strong, inclusive culture. It's about attracting the very best talent from all backgrounds. It fuels innovation. Ultimately, it drives organizational success.
It's leveraging these principles to build a better, more effective organization. So the question for you, our listener, is, knowing all this, how will you proactively champion equity and inclusion in your workplace?
How will you turn compliance from a necessary task into a real strategic advantage? Something to think about.